If your company uses AI in any way, chatbots, recommendation engines, automated decisions, and you do business in Europe, you have until August 2026 to comply with the most sweeping AI regulation in history. Miss the deadline and you are looking at fines up to €35 million or 7% of global revenue. Here are the 7 things you need to do right now. The EU AI Act entered into force on August 1st, 2024. It is the world's first comprehensive legal framework for artificial intelligence, and it applies to any company that places AI systems on the EU market or uses AI whose output affects people in the EU, regardless of where your company is headquartered. If you're a US startup with European customers, this applies to you. The Act classifies AI systems into 4 risk levels: unacceptable risk, banned outright; social scoring, manipulative AI, real-time biometric surveillance in public spaces; high risk, strict requirements. This includes AI used in hiring, credit decisions, education, law enforcement, and critical infrastructure; limited risk, transparency obligations, chatbots, deepfakes, AI-generated content; minimal risk, mostly unregulated; spam filters, AI in video games. Here's the critical point. If you use AI for anything that touches customer decisions, employee evaluations, or automated processing, you are almost certainly in the high-risk or limited-risk category, and that means obligations are coming. This is the foundation. You need to map every AI system your company uses or develops to one of the 4 risk categories defined in the Act. The common mistake here is assuming your AI is minimal risk because it seems simple. A chatbot that recommends products, limited risk, transparency required; an AI that screens job applications, high risk, full compliance framework required. Your first step: create a spreadsheet. List every AI tool, model, or automated system your company uses. Include third-party tools. Yes, that means your HR screening software and your customer support chatbot. Once you've classified your systems, you need formal documentation. Article 11 of the Act requires technical documentation that covers what the system does, what data it was trained on, how it was tested, and what its known limitations are. The common mistake is treating this as a one-time exercise. This documentation must be kept up to date. Every model update, every data change, every performance shift needs to be recorded. Your first step: for each AI system on your inventory, document the purpose, input data, output decisions, and known failure modes. If you're using a third-party AI, request their technical documentation. You are responsible for compliance even if you didn't build the model. Article 14 requires that high-risk AI systems are designed to allow effective human oversight. This means a qualified person must be able to understand the AI's outputs, decide whether to follow them, and override or shut down the system when needed. The common mistake is making human oversight purely ceremonial. Having someone click approve on every AI decision without understanding what they're approving does not meet the standard. The Act specifically requires that the human overseer can fully understand the capacities and limitations of the system. Your first step: for each high-risk system, define who the human overseer is, what training they need, and what authority they have to override the AI. If your AI system interacts with people, those people need to know they're dealing with AI. This applies to chatbots, AI-generated content, deepfakes, and emotion recognition systems. Article 50 is specific. AI-generated text, audio, images, and video must be labeled as such in a machine-readable format. If you're generating marketing copy, customer emails, or social media content with AI, it needs to be disclosed. The common mistake is burying the disclosure in terms of service. The transparency must be clear, timely, and accessible at the point of interaction. Your first step: audit every customer-facing AI interaction. Add clear AI disclosure wherever a person might reasonably believe they're interacting with a human or consuming human-created content. For high-risk AI systems, Article 27 requires deployers to conduct a fundamental rights impact assessment before putting the system into use. Think of it like a DPIA under GDPR, but specifically for AI's impact on people's rights. This assessment must evaluate the risk of bias and discrimination, the impact on vulnerable groups, and the potential harm if the system fails or produces incorrect outputs. The common mistake is assuming your GDPR data protection impact assessment covers this. It does not. The AI Act assessment is a separate requirement with different criteria. Your first step, download the EU's FRIA template when published. In the meantime, for each high-risk system, document which fundamental rights could be affected and how you mitigate those risks. You need a governance structure, someone accountable for AI compliance, clear policies, and internal processes. This is not optional for companies deploying high-risk AI. The common mistake is assigning this to your existing data protection officer and moving on. AI governance requires distinct expertise in model risk, algorithmic fairness, and technical safety, not just data privacy. Your first step, appoint an AI governance lead or committee. Draft an internal AI policy covering acceptable use, procurement standards, risk assessment procedures, and incident response. Article 4 of the Act makes this mandatory, and it applies to all providers and deployers of AI systems, regardless of risk level. Staff who operate or oversee AI must have sufficient AI literacy to understand what the system does and what can go wrong. This is arguably the most overlooked requirement. The common mistake is assuming your technical team doesn't need training because they already know AI. AI literacy under the Act means understanding regulatory obligations, bias risks, and oversight duties, not just how to prompt a language model. Your first step, schedule AI literacy training for Q3 2026 at the latest. Prioritize managers, HR, procurement, and anyone who makes decisions based on AI outputs. Document all training for compliance records. Here's your compliance calendar. February 6, 2025. Already passed. Prohibited AI practices are now banned. If you're using social scoring or manipulative AI, you're already in violation. August 2, 2025, governance and general-purpose AI obligations take effect. This includes AI literacy training requirements under Article 4. August 2, 2026, the main event. Full obligations for high-risk AI systems. Classification, documentation, human oversight, transparency, fundamental rights assessments, all must be in place. August 2, 2027, full enforcement for all remaining provisions, including high-risk systems listed in Annex 3. That August 2026 deadline is approximately 16 months away. For organizations that haven't started, that's an extremely tight timeline to inventory systems, build governance frameworks, train staff, and implement technical controls. The penalties are real, up to €35 million or 7% of total worldwide annual turnover for the most serious violations. For prohibited practices, it's even higher. These are GDPR-level fines applied to a much broader scope of technology. If you found this breakdown useful, hit subscribe. I cover AI regulation, data privacy, and compliance in plain language. No legal jargon, just actionable steps. Drop a comment below. Has your company started preparing for the EU AI Act, or is this the first you're hearing about it? I want to know where businesses actually stand right now. Next week, I'm breaking down the specific documentation requirements, what exactly your technical files need to include, and a free template you can use to get started. See you in the next one.